Thank you, Tania, for that introduction. Oh, the sun is out. Hallelujah. And I am all that is standing between you and lunch. So Evangeline knows that I'm nervous about being too long-winded, so I promise I won't be. And I'm going to put my glasses on because I'm old enough that I can't see without them. So I can now say good afternoon, not good morning. So good afternoon. Good afternoon. I'm really happy to be here at the National Black Pre-Law Conference. I really want to, again, laud Evangeline because this work is amazing, what she has put together for you all. So let's give her yet another round of applause. As Nicole said, this kind of thing didn't exist when I was thinking about law school, and it's an incredible resource. So kudos to you on a day when it's sunny in Boston, which I went to school here, it doesn't happen often, being here. What I'm here to help you answer, I hope, is the question of why go to law school? You probably already know that law governs every aspect of our society, from the lofty words of the Constitution to the lowliest local zoning ordinance. The role of the law is to impose order on the chaos of human interaction and to provide guardrails to prevent us from being subjected to the arbitrary whims of those in power. Well, I hardly need to tell you that the rule of law, the concept that no person is above the law, is under attack in our country like never before. Clearly, our country could benefit from having more people studying law who understand the way in which our system is supposed to work. But I would argue that for Black people, the study of law is so much more than that. The study of law gives us context for our place in American history and our role in shaping it. It helps us understand just how the law has been used alternately to deny us our autonomy and then in fits and starts to afford us a measure of the rights we should have had all along. At the birth of this nation, the Constitution deemed us equal to no more than 3/5 of every white person, our humanity at a 40% discount. And then, after the Civil War, they passed the 13th, 14th, and 15th Amendments to tentatively grant us the rights to be paid for our labor, the right to vote, and the right, allegedly, to equal protection under the law. But then in the backlash after Reconstruction, Jim Crow laws were passed that constricted our freedom in order to reinforce white supremacy. 100 years later, Jim Crow was dismantled through the combination of brilliant legal strategy and brilliant activism, which led to Brown v. Board, which Conrad already spoke about, the decision that overturned separate but equal, and the spate of civil rights laws enacted in the 60s that's responsible for all of us being able to be here today. The study of law, in my view, makes the invisible visible. We talk a lot about structural racism. Well, the study of law is the study of the architecture of those structures. Studying law will provide you with an understanding of how it has been used throughout American history to cement Black people's place at the bottom of a racialized hierarchy, but also give you the tools with which to fight that. By studying law, you'll come to understand that the segregated, decaying neighborhoods that we were often consigned to is not because of anything about us, but they were actually the bastard children of a pernicious type of restrictive covenant that you'll study in property law, and the redlining that the Federal Housing Administration codified in the Code of Federal Regulations, which you'll study in administrative law. And those of you who have been questioned about whether you belong in your predominantly white college or university, and for those of us who went to PWIs who hasn't been, will learn that the question is part of an unceasing pattern of resistance to equal educational opportunity for Black people that has a long history stretching from Sweat v. Painter in 1950 to the Regents of State of California versus Bakke in 1978, to Fisher versus the University of Texas, otherwise known as Becky with the bad grades, in 2016, and continues right now In Students for Fair Admissions versus Harvard, the case currently being litigated right downtown as we speak, you will learn that those questioning your right to attend any predominantly white institution are revealing much more about their own investment in white supremacy than anything about your intellectual ability. Law school will give you the receipts. We belong everywhere. Everywhere. Every law firm, every law school, every law department, everywhere. Don't let anybody tell you anything different. A little church on Saturday. And I'm a lapsed Catholic, so that's really, talk about imposter syndrome. But the study of law clarifies how, more than any other group in American history, Black people have used the law to challenge this country to live up to the promises in its Constitution and make the Bill of Rights manifest for all Americans. While it's true that the guarantee of equal protection under the law led to the dismantling of legal segregation, it was also the doctrinal foundation for reproductive rights for women in Roe v. Wade and marriage equality for LGBT people in Obergefell v. Hodges. Everybody's rights stand on our shoulders and the struggles that our people fought. If I'm being honest, though, when I was sitting where you are today, I had no such lofty understanding of how studying law would help me contextualize Black people's place in history. I didn't fully understand that law was a tool that could be wielded by brilliant lawyers to secure freedom for marginalized people, or by unscrupulous ones to deny that freedom and cement unearned advantage. But as one of the progeny of Brown v. Board, the generation of Black students that benefited from school integration before the Burger Court shut down virtually every tactic used to integrate schools, from busing to regional integration plans, I understood that brilliant Black lawyers had expanded the scope of opportunities that my generation could enjoy. I went from attending an all-Black elementary school in Bed-Stuy, do-or-die Brooklyn, from kindergarten through second grade, to being bused in third grade with a bunch of Black children to an all-white elementary school in Flatbush. There, we were met by angry white parents protesting. Y'all think it was just in the South? Oh, as what they say, hell to the nah, not just there. They were very upset that New York City had finally, belatedly, decided to actually comply with the Supreme Court's mandate that schools be fully integrated. And I was not in elementary school in 1958. I'm not that old. It was considerably after that. So, not too much after that, but considerably. Not gonna say. And then after my family moved to New Rochelle in New York's Westchester County, I was attending schools that had only recently been desegregated in Westchester after Black parents there sued the city and were represented by the NAACP Legal Defense Fund. And in a lovely twist of fate, that case was litigated by Constance Baker Motley. So, and then, thanks to the doors opened by these same groundbreaking lawyers, I was able to attend Harvard College and then NYU Law School. So when I think of my own career trajectory, I think about the people who inspired me to become a lawyer. And I've tried to use them as a touchstone against which to measure my own decisions throughout my career. My decision to become a lawyer was inspired by the heroism of the crusading lawyers of the NAACP Legal Defense Fund, led by the legendary Thurgood Marshall. And I was acutely aware that but for their work, my own career as an entertainment lawyer, a partner in a predominantly white law firm, would not have even been possible. So when I was entering law school, I was mindful of the debt that I owed these remarkable men and women, and I asked myself two questions. How could I emulate them, and how could I repay the debt that I owed them? And the answer that I came up with was to try to honor their work, to live by their example of excellence, diligence, and courage. Now, what does that mean? So, in my view, it took excellence for Charles Hamilton Houston and Thurgood Marshall to see the germ of a legal theory that could eradicate invidious discrimination based on race in a footnote to a Supreme Court case involving interstate shipment of dairy products. This is no lie. When you go to law school, you'll learn about it. And the lesson I learned from that was, don't skip the footnotes. Read the dissents and the concurring opinions. In other words, be thorough. Because law is a potent weapon for change that you can only effectively use if you master it. As a first-year law student, I sat in the front row and volunteered in class so often I was the center square in a game they call Asshole Bingo. It's the very eager kids that are like, pick me, pick me. Most people are slinking in the back saying, God, I'm not prepared. John earlier talked about the Duck Hunter case. I was the one who would have been like, no, that was the Fox Hunter case. That would have been me. But, sometimes that works. And the point is, I didn't always know that whether or not I had the right answer, but I knew whatever my answer was, it was grounded in thorough preparation. Be prepared. Do the work. People say law school's hard. Yes, it is hard. But if you do the work, I don't want people to be scared of that and intimidated by that. We've all done it. You can all do it. Smart is not something you are, it's something you earn by the work. Put the work in, and you can all do that. You're all here, putting the work in on a Saturday when the sun is out in Cambridge. Doesn't happen often. Secondly, diligence. It took diligence for Thurgood Marshall and the lawyers of the LDF to use the Caroline Products articulation, that's the case about dairy products, of a strict scrutiny standard in cases, for standard of review rather, for cases impacting a discrete and insular minority in a series of cases over 10 years. They had a 10-year game plan to use this, to get the Supreme Court to use it to knock down separate but equal when it came to black people. And they picked their cases, they picked their plaintiffs, and they, over 10 years, got to Brown v. Board in 1954. That's diligence. And I've tried to follow the example set by Thurgood Marshall and Robert Carter and Jack Greenberg and Constance Baker Motley by being diligent in the work that I do. In my early years, when I was representing clients like Public Enemy or the producer Chucky Thompson, who did the notorious B.I.G., and yes, I was there when Biggie met Faith. Yeah, real talk. But what I would say to clients is, if you are looking for someone that's going to hang out with you in the studio or at the club till midnight, I'm not your girl, because I need to be lucid at 9 in the morning when I'm reading your contracts and negotiating your deals. Be diligent. Don't think that entertainment law is hanging poolside with Denzel. It's not. Trust and believe. And the reason for that is that regardless of what area of practice you end up entering, whether people are entrusting you with their fate, whether it's their liberty in a criminal law case, whether it's the fruit of their creativity, like in my field, entertainment law, whether it's someone's rights in impact litigation and civil rights, that's their fate, and they are owed our diligence. And then the last thing is that courage. Clearly, the lawyers that I saw as my role models had to have courage to travel throughout the hostile South in the 50s and 60s. Nicole just talked about the 16th Street bombing that 4 little girls died in. These lawyers were in those same towns, in those same states, in courtrooms, standing up and arguing for the rights of all black people to be treated equally. And they were taking their lives into their hands to do that work. As you heard, I had the honor of clerking for legendary civil rights lawyer Constance Baker Motley, and she sat in Medgar Evers' house while armed guards were protecting them from the Klan a mere 3 weeks before he was killed in his own driveway. So their courage was not an abstract thing, and it made it possible for all of us to be sitting here today. And we need to understand in times like these that courage is not the absence of fear. It is the acknowledgement of fear and acting anyway because the stakes are that high. I mean, imagine for a moment that you're Constance Baker Motley and you're constantly leaving your husband and your young son in New York City to travel to the Deep South to litigate civil rights cases. You're leaving a son so young. You know, Nicole was talking about her son at the White House party. Constance Baker Motley's son was so young when she was litigating these cases that he would kiss the television screen when he saw her on the news. So that's what she was doing. And she's leaving and staying in the homes of NAACP leaders in Mississippi and Alabama and Georgia, and they're living under the constant threat of violence. You know, imagine arguing in hostile courtrooms, but then winning the right of Charlene Hunter Galt to attend the University of Georgia and the right of James Meredith to attend the University of Mississippi, Ole Miss. And can we, in good conscience, let all of that sacrifice be in vain? We're all going to need to find that same courage in the years ahead because it's real out here. We're confronted by an administration and a Republican Party that's hell-bent not only on reversing all of the accomplishments of our first black president, but all of the gains that all of these people have made literally in the century before that. They're trying to take us back to Jim Crow 2.0. So, you know, and even though Tuesday's election has resulted in a Democratic House majority and Democratic control in many states, the sobering fact is that 40 to 50% of our fellow citizens in Florida, Texas, and Georgia voted for candidates who ran explicitly racist campaigns. And around the country, many other folks in Indiana, Tennessee, and Missouri voted out of hatred and fear. And these sentiments are a grave threat to democracy in a multiracial and multicultural country such as ours. The threat that we face is real, and if our republic is to be saved, it is going to be lawyers that save it. In the 2 years since Trump has been in office, lawyers have been the only ones with the ability to blunt the impact of some of his most harmful policies. At the federal level, only the judiciary has fulfilled its constitutional duty to serve as a check on the executive branch's unconstitutional abuse of power. Elected officials like state attorneys general have been the ones to challenge Trump's rampant corruption, and impact litigation organizations like the NAACP Legal Defense Fund and the Lawyers Committee for Civil Rights Under Law have been the ones fighting rampant voter suppression in states like Texas, North Carolina, and Georgia. And on Election Day earlier this week, volunteer lawyers from all different fields fanned out in states around the country to be poll watchers and to staff voter helplines to protect the franchise, which is the right that's protective of all other rights. The choice is before each one of you. Who has inspired you to go to law school? And what do you owe those people that have inspired you? Know that every lawyer takes an oath to uphold the Constitution and the laws of the United States. Now, more than ever, our country needs lawyers who believe in our Constitution and who will fight to uphold the rule of law. I hope that each one of you will heed the call and join our profession. For our ancestors, for our people, and for our country. We need you.